here is where a lot of my own colleagues and attorneys screw up and do their clients a disservice. They tell them that they need a modification of custody. No! Custody is not being changed here. So you get divorced and you think you're done, right? Nope. The divorce is not always the final chapter in a couple's story. Why is that? Because over time, circumstances change. Incomes fluctuate, job losses may occur, people relocate, they run into health issues that affect their income and their ability to parent their children, and then they also get remarried sometimes, which changes the dynamics and can cause a need for a modification. As a divorce attorney, I frequently find myself guiding clients and former clients through these kinds of modifications. So I'll talk with you about that for the next few minutes. I'll educate you on the intricacies of post-divorce modifications, explaining the legal process and what it involves, and the required elements that you must consider before you file for a modification. So today I'm just discussing modification of child custody and parenting time, and you can look on our YouTube channel for other videos on modification of child support, spousal support, also known as alimony, and even property modifications. All right, let's discuss the legal framework for a modification. So the modification process typically involves filing a motion with the court in the appropriate county, which could change if one or more of the parties have moved since the divorce. The party seeking the modification, known as the moving party or petitioner, usually must serve the responding party in the responding party's county and must demonstrate that there is a significant change in circumstances that justifies the requested modifications. Now, this change must be substantial enough to warrant revisiting the terms of the divorce judgment. One of the most common areas for modification is child custody and parenting time arrangements. As children grow, their needs and preferences evolve. A modification may be sought if one parent wishes to relocate, or if the child's school schedule changes, or if there are concerns about the child's safety or well-being in the current arrangement. What you need to know is that the courts prioritize the best interests of the child when considering the modifications. Memorize that phrase, the best interests of the child. You're going to hear that a lot in everything to do with modifications. The courts don't care as much about what the parents want as they do about how it will affect the children. Evidence supporting the proposed changes, such as a child's adjustment issues or improved circumstances of a parent, will be crucial in making a compelling case. A family law attorney plays a pivotal role in presenting this evidence effectively and advocating for the client's position. Child custody modification cases involve a pretty thorough examination of the current custodial arrangement as well as the future proposed arrangement. Factors such as the child's age, their preferences, and any evidence of a parent's inability to provide a stable and supportive environment are all carefully considered. And in cases where one parent seeks sole custody or a modification to the existing custody arrangement, the court will oftentimes, probably more than half the time, appoint a guardian ad litem to the case. Now, the guardian ad litem's role is to get to know the parents, the kids, all the circumstances, anyone else who could shed a helpful light on things, and then make a recommendation to the court about how they should rule in the case. Typically, the guardian ad litem will release a summary of their recommendations to the parties in the form of a report, and do it in the hopes that it'll keep the parties from having to go to court, and it'll allow them to come up with their own resolution on the custody issue with that guardian's recommendations in mind. So let's look at a potential modification case, and this is an example of one of the most contentious and hard-fought modifications there is, so I thought it'd be a good example. Supposing a custodial parent wishes to relocate to a different state and gives adequate notice, and the party who's staying objects to the children moving out of state. The court will assess how this move to the new area might impact the children's relationship with the non-custodial parent, as well as how it will affect them by being pulled from the soil they've been planted in and grown roots in, and then it's up to the relocating parent to attempt to demonstrate the substantially valid and compelling reason for the move and present a revised parenting plan that maintains the child's connection with the non-relocating parent. Communication and co-parenting skills are very important during these proceedings. The courts often require parents to try and reach agreement through negotiation or mediation prior to resorting to a courtroom battle, and an experienced family law attorney with a solid expertise in child custody matters can definitely be a solid advocate, not only in advising what is and what isn't reasonable, thus helping with the negotiations and the mediation, but also in the courtroom in presenting your case if the negotiations prior to your day in court fail. Now, at my law firm, we always present everything from the standpoint and the perspective of the child's rights, because I know that the courts don't really care what the parents want. I know that's blunt, but it's true. If you find yourself in the courtroom with your children's other parent, then the court already knows that you two want very different outcomes, and the court will be deciding what's best for the children, which may not be what the children even want for themselves. For example, the children might want to make the move, but if the court feels it's best to stay put, they may deny the move. Or conversely, the children may want to stay where they live now and not make the relocation, but if the court feels that the children's lives would be substantially better, so much so that it overcomes all the upheaval of the move, then the court will order that the children may be relocated to that new location. Okay, another type of modification is a modification of parenting time. Again, after putting the initial parenting plan in place, circumstances can change that warrant a modification of the time that one or both parents spend with the children. A modification of parenting time is different than a modification of custody, so pay attention while I explain those differences. In a modification of parenting time, one of the parents seeks to change the amount of time that they spend with the children, but they're not seeking to modify who the primary custodial parent is. I like to explain things through examples, so here's one for this type of modification. Suppose at the time of the divorce, dad is a long-distance truck driver who is only home once every couple of weeks and he's home midweek. So the parties have a parenting plan that may have him seeing his kids for dinners on the weeknights, which are also school nights, that he's home in between trips, and perhaps he's got them on alternating holidays. Now, he changes jobs, he becomes a local or short distance truck driver, he's home every night, perhaps with an overnight occasional trip during the week, but he's home every weekend. And dad wants to start spending time with his kids on the weekends, maybe Thursday evening to Sunday evening or even Monday morning. He wants to take them after school on Thursdays, have an overnight with them, get them up and off to school on Friday morning, and then spend the weekend with them and either bring them back to mom on Sunday night or bring them to school on Monday morning, and then he goes to work. Now, this is a totally doable schedule now, given his change in his job. How can he make this happen? Well, the answer is to find a fantastic family law attorney who understands all this stuff and then file a modification of parenting time. And here is where a lot of my own colleagues and attorneys screw up and do their clients a disservice. They tell them that they need a modification of custody. No! Custody is not being changed here. He is not looking to become the primary caretaking parent. He just wants more time with his kids. Now he's able to have it thanks to his schedule allowing that. So all he needs is a modification of his parenting time, a modification of the parenting plan. It blows my mind how many people get this wrong, and I'm explaining this to you here so that you don't get it wrong and that you understand the difference between a modification of custody and a modification of parenting time. A modification of custody means changing who the primary caretaking parent is, and a modification of parenting time means just changing how much time the non-custodial parent gets to spend with their kids. And guess what? The requirements for the non-custodial parent to be able to get that modification of parenting time are actually pretty low. As long as the dad in this example can show that there's been a change in circumstances that enables him to actually implement that new parenting plan, and as long as he can show that it would benefit the children for that new parenting plan to go into effect, there's a really good chance that the modification of parenting time will be approved by the court, even if the custodial parent disagrees with it. Now, the other parent will be given their opportunity in court to express their reasons for opposing that modification of the parenting time, but the court is looking for what's in the best interest of the children, and it is the state of Georgia's position that the children need to have a close and continuing relationship with both parents. It's even in language within the courts, that phrase, close and continuing relationship with both parents. I have never seen a modification of parenting time get flat out rejected by the court. Most of them actually settle pre-trial. It's very rare that these actually go to court. If you're a parent going through any kind of modification of child custody or parenting time, regardless of which side you're on, whether you're the parent seeking the change or the parent opposing the change, I strongly urge you to do what is best for your children without putting your own feelings about your ex into the mix. There are so many kids who are being messed up because they got caught in the crossfire between their parents. Everything from parents being difficult about exchange times and locations, to trying to prevent the other parent from seeing the kids, to trying to replace a parent by inserting a new love interest into the mix. Even parents who back away from seeing their children because of issues they have with the other parent. As a voice for your children and as a single dad myself, I ask you to please take a step back, get into the heads and hearts of your kids, and think about what they want and what's truly best for them, and do it without the distortion of your own emotions. Hey, thanks for watching this video. Be sure to click subscribe, like, follow, and turn on the alerts so that you'll get notified when we post our newest videos. Please share these videos and leave us some comments, ask us questions, tell us what other topics you'd like for me to talk about. Join our Facebook group at Georgia Divorce and Custody for more information. And as always, I look forward to seeing you on the next video.